Do you guys know that you can be punished even if you are not at fault? Doesn't it sound a bit weird? How can we be held liable even if we haven't done anything wrong? Doesn't law punish people who are at fault? Well, in the present video, we are going to touch upon a topic which is an exception to the general rule on liability under tort law. Normally, a person is responsible or liable for the consequences which arise from his own fault or negligence. And the best part about this video is that this is the most often tested area of torts in Clat and other school entrance exams. It has made an appearance recently in the Clat 2020. There are two exceptional circumstances wherein liability arises even if there is no fault, including negligence on the part of the defendant. These are strict liability and absolute liability. Let us understand strict liability through a factual situation. The defendant got some independent contractors to construct a water reservoir on his land. Now, just when the water was filled into the reservoir, it leaked and entered the plaintiff's coal mine, causing extensive damage. Plaintiff suffered loss and he sued the defendant. What would have defendant done in this case? He tried to evade his liability, saying he was never at fault, and it was the negligence of the independent contractor. But courts have some enormous powers. They not only held the defendants liable, but even came up with a new rule called strict liability. Court said that if there are three ingredients in the factual situation of a case, defendants will be liable under strict liability. Now, what are these three things? First, non-natural use of land must have taken place. Second, there must be some dangerous thing brought by the person on his land. And third, that thing must have escaped and caused mischief. The factual scenario we discussed are the facts of the case which you must have heard of, which is Rylance versus Fletcher, where the court evolved the principle of strict liability. Interesting, isn't it? Let's dive into what those three ingredients actually mean. Non-natural use of land here does not mean artificial. Rather, it refers to the natural and usual use of land. So, growing trees and constructing a house with 100 liters water tank, both would be considered natural use of land. Unlike constructing a huge reservoir, which is an unusual thing. Hence, non-natural use of land. Can you guys think growing trees bearing poisonous fruits would be natural or non-natural use of land? Yes, it would be a non-natural use of land. The next important thing to check is whether the thing brought by the person on his land is dangerous or not. Here, dangerous means capable of causing harm. So, a thing could be inherently dangerous like a poisonous tree or a hazardous chemical, or it could become dangerous because of its volume and accumulation, like water in a huge water reservoir. So, water, even though not inherently dangerous but capable of causing harm due to its sheer volume. So, don't store anything in a huge quantity, right? The last but not the least is the escape of this dangerous thing which caused mischief, meaning some kind of harm or damage. So, if the damage is caused but the substance is still within the premises, then there is no strict liability. For instance, if we go back to the poisonous trees, let's suppose that the poisonous fruits of the trees fell on the neighbor's garden, eating which he died. Here, the owner of the trees would be liable under strict liability. But what if the neighbor had entered the defendant's field for eating the poisonous fruits? Will the defendant be liable under strict liability? No, it won't be applicable as there was no escape. This is the rule of strict liability. However, the court also prescribed certain limitations to the rule of strict liability in the form of certain defenses which were available to them. Law and other limitations are perfect match. It exists almost everywhere. So what are the defenses available in case of strict liability? First, a very important point, plaintiff's own default or plaintiff the wrongdoer. Second, act of God or vis major. Third, shared benefit or consent. And fourth, act of the third party. Surely by now, most of you must be thinking that with so many defenses available, the liability does not really remain very strict, isn't it? This was the exact issue which the Supreme Court of India faced in the wake of Bhopal gas tragedy. Hence, at the next opportune moment, which is commonly known as the oleum gas leak case, which is MC Mehta versus Union of India, the Supreme Court established a brand new rule of no fault liability, which has been termed as absolute liability. The rule of absolute liability made three specific changes to the rule of strict liability. The first was that the apex court took away all the defenses available with the defendant. Then the requirement of escape of dangerous thing was also removed. Further, they specified that the rule would apply only if the enterprise is engaged in hazardous and inherently dangerous activities. So, the rule of absolute liability is much wider in application than the 2-century-old principle of strict liability, which was required to be modified in lines with the modern times. I hope you guys now know when you can be held liable even if you are not at fault. Now think about the situation about the gas leak which happened from LG Polymers chemical plant in Visakhapatnam, which happened in 2020. Which principle will be applicable here? Write it down to us in the comment section below with your answers and reasoning. Happy learning!